in the first regular session of the 17th Congress is hereby called to order. Let us observe a minute of silent prayer. Amen. Secretary, please call the roll.
Roll call of members. The Honorable Senators Angara, Aquino, Binay, Cayetano, De Lima, Drilon, Ejercito, Escudero, Gatchalian, Gordon, Hunasan, Hontiveros, Lacson, Ligarda, Pacquiao, Pangilinan, Po, Recto, Soto, Trillanes, Villanueva, Villar, Suberi, Senate President Pimentel.
Angara is present. Counted?
With 18
Senators present, the chair declares the presence of a quorum. Majority Leader?
Mr. President, I move that we defer the approval of the Journal of the 50th Session Tuesday, January 17. At a later hour, we're still looking it over.
Is there any objection? There being none, the motion is approved.
Mr. President, before we proceed with the reference of business, may I call on the following members of the Senate? Senator Greg Onasan, Senator Bam Aquino, Senator Ping Lacson, Senator Lone Legarda, Senator Grace Poe, and Senator Win Gatchalian, together with Senator Chis Escudero and Sonny Trillanes, and Senator Drilon and Senator Recto, to a meeting in the lounge as I move to suspend the session because we are going to greet the Senate President a very happy birthday. So with that, Mr. President, I move to suspend the session and greet the Senate President a very happy birthday.
Thank you for your
Ask
advance.
the following names I mentioned join us in the lounge, Mr. President.
Thank you for your advanced birthday greetings. Session is suspended for a few minutes.
Ready to resume, Mr. President.
Session is resumed.
Mr. President, would like to acknowledge some guests of the Senate, the visitors of Senator Pacquiao from Monterey, California, headed by Ms. Riza Crisostomo. And like to acknowledge also the presence of the Philippine Youth International, Philippine Youth Achievers, Mr. Nelson Lin, Mr. Philippine Youth World Marin Abel, Mr. Philippine Youth World May Corpus, Ms. Philippine Youth International Angela Muhi, and also we'd like to welcome the students from South Mansfield College in Muntinlupa City, headed by Dr. Genevieve Ledesma Tang, Mr. President.
Welcome to all of our guests.
Mr. President, the other day, Resolution 256, introduced by Senator Franklin Drilon, the Senate Senator President Pro Tem, was referred to the Committee on Civil Service, Government Reorganization, and Professional Regulations. However, some of our colleagues objected to the referral. Hence, a motion for reconsideration of the referral was made and approved thereafter. So as a result, a matter of course, the subject resolution was referred to the Committee on Rules to decide on the matter. Mr. President, I had the chance to listen to all the arguments and sentiments of our colleagues. As a matter of fact, I took into consideration the comments and arguments by some of the senators who did not participate in the debate but shared their valuable inputs. In fact, I was ready to come up with a resolution yesterday. But some other things came up and issues came up, and I received a letter from the Senate President, who is now the presiding officer, This was concerning a letter of referral, regarding the referral for the proposed Senate Resolution 256. So may I read into the records the sentiments of the Senate President? It says, Dear Senator Soto, proposed Senate Resolution number 256, titled Resolution Directing the Committee on Civil Service and Government Reorganization to look into the possible reorganization of the Bureau of Immigration, calls on the oversight power of Congress to look into the issues surrounding the Bureau of Immigration and, if warranted, to recommend the BI's reorganization. While the Committee on Civil Service, Government Reorganization, and Professional Regulation has general jurisdiction over the reorganization of the government or any of its branches or instrumentalities, this general jurisdiction yields to a special rule on the matter. In this case, there is a particular committee that has oversight powers over immigration matters, and that is the Committee on Justice and Human Rights. Since the recommendation to reorganize the BI is a result of the oversight power of Congress, then it is my opinion that the appropriate referral is to the Committee on Justice and Human Rights. In the event that a bill for the reorganization of the BI will be subsequently filed as a result of the investigation under PS Resolution 256, it will be imperative for us to examine the extent of the reorganization proposed therein. If the bill were to mandate the transfer of some of the BI's functions to other government agencies, then the referral shall be to the Committee on Civil Service, Government Reorganization, and Professional Regulation. On the other hand, if the bill were to merely streamline functions within the BI, then the referral shall still be the Committee on Justice and Human Rights. Thank you and kind regards. Very truly yours, Aquilino Coco Pimentel III. Now, Mr. President, I really have to put a lot of weight on in your letter. But I also would like to place on record that as of yesterday, I was ready to come up with a resolution directing the committee referral to the Committee on Civil Service and then the Committee on Justice and Human Rights. But earlier, I met with the members of the Committee on Rules. I read your letter. I told them of my original intention. So, with the permission of the Chamber and the members of the Committee on Rules, as we have agreed earlier, I would like to report to the body the proposal that we took into consideration after we took into consideration the arguments and incorporate therein the intentions that were mentioned and unmentioned on record relating to PS Resolution 256. Hopefully, Mr. President, this will nurture a peaceful atmosphere in the Senate, considering that we need to pass a number of legislations before the adjournment of the session in March. And in order to do that, we need a conducive working environment by resolving this issue at the soonest possible time. So with that, Mr. President, I recommend that we refer Resolution 256 jointly to the Committee on Civil Service, Government Reorganization, and Professional Regulation, and the Committee on Justice and Human Rights, treating both as the primary committee referral. Mr. President, this has been done before. Now, the implication of this setup is that the Civil Service Committee will deal exclusively on the reorganization aspect of the Bureau of Immigration, which is within their competence and jurisdiction, while the Committee on Justice, on the other hand, will only touch on the aspect of administration of Bureau of Immigration, which falls under its domain. As a consequence, the two primary committees shall come up with separate committee reports if they wish, each dealing with separate concerns within the bounds of their jurisdiction, as earlier mentioned. Nevertheless, of course, Mr. President, we cannot preclude the Blue Ribbon Committee from conducting its own hearing on the contentions mentioned in 256, particularly the issue on corruption. It can be confined to that. Besides, it's the only committee that can conduct a hearing relative to the conduct of public officials, and the only committee that can, on its own initiative, call for a hearing. Now, in view of the foregoing, Mr. President, may I convert this manifestation into a motion? So I so move, Mr. President, that the PS Resolution 256 be jointly referred to the Committee on Civil Service, Government Reorganization, and Professional Regulation, and the Committee on Justice and Human Rights.
There is a motion acting on proposed Senate Resolution number 256 that it be now referred jointly to the Committee on Civil Service, Government Reorganization, and Professional Regulation, and Committee on Justice and Human Rights. Any objection to the motion? There being none, the motion is approved. Senator Pangilinan.
It's just a quick manifestation. Mr. President, I would just like to manifest that the earlier motion and the adoption of the same has precedent, Mr. President. This has happened on several occasions in previous Congresses wherein there have been joint referrals of a particular resolution, and precisely a specific aspect of the resolution is to be tackled by one committee, while another aspect is tackled by another committee. For the record, Mr. President.
Thank you for that manifestation.
Thank you, Mr. President. As a matter
Majority
of fact,
Leader.
I think the Senator Pangilinan was then the Majority Leader during that time, that one of the incidents happened. Anyway, Mr. President, with the permission of the body, I move to resume consideration of Senate Bill 1210 under Committee Report number 4.
Is there any objection? There being none, the motion is approved.
This is the measure on the expanded Anti-Wiretapping Act, Mr. President. The parliamentary status of the measure is that we're now in the period of interpellation. So I move to recognize the sponsor, Chairman of the Committee on Public Order and Dangerous Drugs, Senator Pampilo Lacson, and to interpellate. There are a number of members who wish to interpellate, but today we would like to ask that we recognize Senator Laila de Lima to start the interpellations.
Senator Lacson as a sponsor is recognized, and Senator De Lima is also recognized for interpellation.
Thank you, Mr. President, and thank you, the distinguished gentleman from Cavite. If you would wish, please, to yield to several questions.
Gladly and willingly to probably the most wiretapped individual on planet Earth.
Thank you for acknowledging that.
But it may comfort you to know that more than a decade ago, I was also holding the same distinction of being the most wiretapped individual. And not only that, hindi lang po yun. If we look at the gentleman on my left,
Who is in your left?
probably 5 to 6 decades ago, he was the title holder from 1986 to 1989. He was the most wiretapped individual at the time. Levity aside, Mr. President, before I yield to your questions, may I just, for the record, give some preliminaries, no? And mention some rationale, no? Rationale for amending Republic Act 4200. First, it is an outdated law, no? It is a 52-year-old law having been passed in 1965. And new technologies have appeared in the marketplace and continue to outpace existing surveillance law, the existing surveillance law, the RA 4200 for that matter. And Congress needs to adopt a new law that is both responsive and adaptive to such changes. Republic Act 4200 is already outdated, as I said, and it will be a stretch to argue that it can cover existing and future means of communications, conversations, etc., etc. We aim to expand the coverage of offenses subject to be subject of exemption. And we have listed down the other offenses aside from those already covered under 4200. So with that backdrop, Mr. President, I'm willing to yield to your questions.
Thank you, Mr. President. Undoubtedly, this measure is a perfect example of a piece of legislation where Congress, as policymakers also, should be conscious about balancing of interest here. On one hand, the interest of the state to strengthen or enhance the capacity of the law enforcers, to empower the law enforcement, and on the other hand, to continuously protect rights, especially right to privacy. I believe, this representation believes, that while there are indeed a lot of improvements in the proposed measure in trying to make such delicate balancing act between two equally important and primordial interests, I'd like to say that this can probably be effective in terms of precluding or deterring more crimes prohibited under this measure committed by private citizens or non-state actors or those not involved in the enforcement of laws. But insofar as precluding, deterring, and perhaps discouraging, prohibiting acts of wiretapping, etc., which is already punishable under the antiquated 51-year-old Republic Act 4200, insofar as state actors are concerned, and I'm particularly referring to law enforcers, investigators within the military and the police organizations, I'm not sure, to be honest about it, Mr. President, distinguished sponsor, that this will be a deterrent. Because right now as we speak, and given the very honest acknowledgement earlier, I know it was meant to be a joke, but I think it was not a joke, that really wiretapping certain public figures is more the order of the day when it comes to our law enforcers or state agents. So, I'd like to begin by focusing on the very title of this measure. And I think, again, before I proceed, may I ask the indulgence of the good sponsor that I'm sure that the good sponsor appreciates or knows where this representation is coming from.
Very much so, Mr. President.
No less than the President has admitted that somehow I'm being listened to, even by a foreign state. And that's a subject of my pending petition before the Supreme Court, the petition for habeas data. I'm not going to dwell on that because of the pending case. I'm going to dwell on that. I'm going to deal with the matter in due time. But can you imagine the highest official of the land openly acknowledging that they are in fact committing an illegal act by listening to a public figure? And I'm referring to myself. The title, this is supposed to be known as the Expanded Anti-Wire Tapping Act of 2016. Expanded. Is the use of the term expanded here reflective only or indicative of the fact that the proposed measure is adding to the list of the crimes under the exception? The
That's just-
general,
Yeah, okay.
please respond. Thank you.
That's just one of the connotation of the word expanded. There are so many connotations. The other connotation is the expansion of the methods or the means to listen to conversations, to wiretap. Because in this day and age of modern information technology, communication and information technology, the other methods cannot be covered anymore under 4200. That is the reason why we amended Section 1. No? And it is all-encompassing, Mr. President. Section 1, it says here, it shall be unlawful for any person to secretly wiretap, intercept, overhear, and listen to, screen, read, surveil, record, or collect with the use of any mode, form, kind, or type of electronic, mechanical, or other equipment or device or technology now known or may hereafter be known to science, or with the use of other suitable ways, arrangements, or means for the above purposes, private communications, conversations, discussions, data, information, messages in whatever form, kind, or nature, spoken or written words of any person or persons without any authorization from all the parties concerned. That is the essence of the word expansion or expanded Anti-Wiretapping Act.
So it's not just about the expansion of the list of the exempted crimes or offenses, but also the expansion of the list of the methods, the means, the devices, etc., to be attuned to the times and especially advanced technology.
That is correct, Mr. President. Not only that, we are also, if I may use again the word expansion, we're also increasing the penalties, no? Including fines, because from 6 months to 6 years, it will now be 6 years to 12 years. And a fine of 1 million to 5 million pesos.
So updating the penalties,
Updating
increasing
the penalties.
the penalties. Now, would it also be correct to say that expansion, or the use of the term expanded, would also refer to additional safeguards
That is correct, Mr.
against
President.
intrusion?
In fact, this bill is adherent to 13 international principles on the application of human rights to communication surveillance. And I can enumerate the 13 international principles if you are interested to find out. But it is a matter of record, and even during the period of committee amendments, because I think we overlooked to include graft and corruption in the list of offenses. So I have already instructed my staff that during the period of committee amendments, we will include violations of RA 6713 and RA 3019.
I thank the good sponsor for mentioning that, because that's also one of my
Amendments.
proposed amendments to include it within
Thank
the
you very much.
coverage or the among the exempted offenses. And going back again, supposed to be to the expanded list of the means of communications. But you will agree with, the good sponsor would agree with this representation that actually under Republic Act 4200, the original law, although it refers more to wiretapping by means of instruments which are already considered outmoded, like dictaphone or
Yes.
dictagraph, dictaphone or walkie-talkie or tape recorder. But if we really look closely at the provision, it seems to encompass even other types of gadgets by the use of the phrase by using any other device or arrangement to secretly overhear, intercept.
That's
that
an
correct?
additional safeguard, Mr. President, because even those that have not been discovered by science or invented by science, it will be covered under this new proposed measure.
And insofar as, again, the expansion or the expanded nature of this proposed measure as to contemplate increased penalties for violation, as I intimated earlier, I'm very much concerned about the violations committed or being committed by state actors or elements of our security forces, both the military and the police. Now, can you tell this body what exactly is the increased penalty imposable for public officers?
Perpetual disqualification from holding public office, on top of imprisonment of not less than 6 years, but not more than 12 years, and a fine of not less than 1 million pesos, but not exceeding 5 million pesos.
Would the good sponsor open to a consideration of a higher penalty?
Of course.
Imposable,
By all means, Mr. President.
insofar as public officers or state actors are concerned?
Being a former Secretary of Justice, you may, I yield that you have more knowledge on the penalties that should be imposed, Mr. President.
This representation, in fact, is thinking about imposing the highest penalty
I-
for violation
I will agree to
of
that,
this
Mr.
act
President.
by state actors.
On some qualified acts, Mr. President, probably.
On qualified acts, whether qualified acts or within the contemplation of the regular application of the law. For as long as there is violation of the wiretapping law by public officials, by state agents, whether in the military or police officer, I think it deserves the highest penalty because they have the capability. And in fact, as I mentioned earlier, this law will not deter them because as we speak, even if there is Republic Act 4200 and it easily covers them already, they continue to violate the anti-wiretapping law. So what good will it do? Through these good reforms, these enhancements and improvements in the law, if we are not going to make the imposable penalty serious enough or grave enough to really create deterrence.
With the permission of the majority of our colleagues here, I will agree with the distinguished lady, Mr. President.
Thank you. I'd like to try to scrutinize certain terms used in the proposed measure. Mr. President, distinguished sponsor, on page 1, line 6, the proposed bill provides for a definition of the prohibited acts of interception and recording. And may I just quote, to secretly wiretap, intercept, overhear, and listen to, screen, read, surveil, record, or collect with the use of any mode, form, kind, or type of electronic, mechanical, or other equipment or device or technology now known or may hereafter be known to science, or with the use of other suitable ways, arrangements, or other means for the above purposes. How does the good sponsor define overhearing and listening to? I asked that question, and I know that even in the original law, it used the phrase to secretly overhear. It is the humble submission of this representation that the verb overhear is a passive.
Nakikimiron, Mr. President. Maski yung nakikimiron, he may be liable.
But to overhear presupposes a situation in which the person hearing has no intention to hear the communication. That's why it's passive. So should it be a subject of a prohibited act?
Well,
As it does
I
not
think
denote
it
an
should-
action, unlike listening. The word listening is an active verb. There's an intention to do the act. So can we
I would like to believe that it should be treated as a matter of defense later on, during the trial. But the mere fact that the person trying or actually overhearing the wiretap conversation, there should be an assumption that there's malice on his part.
Okay.
But he should he can put that up as a defense, that he had no intention to hear, but he just accidentally heard the conversation or conversations being wiretapped, Mr. President.
Because again, the operative word here also is secretly overhear. So per se, to secretly overhear is covered or is a prohibited act, but it could be that in overhearing, it was not the intention of the person concerned to really.
It says here, overhear and listen to.
Yes, overhear and listen
to.
So they should be taken
Screen, read,
together.
surveil, record, or collect.
So they should be taken together.
Yes, Mr. President.
Because it's not just the act of overhearing, but actually listening,
Yes, Mr. President.
actively listening, purposely, deliberately listening. So
And even recording.
Yes,
So hindi na po passive yun. That's already active participation in the commission of the crime.
thank you for the explanation. On page 1, line 8, again, as part of the provision that I quoted, how does a good sponsor define the word screen? And why is it a prohibited act? To screen means first to conceal, to protect something. This is the ordinary dictionary meaning. Or it can also mean to show a movie or a video or to broadcast. And the first meaning of to conceal, to protect something obtained a secondary meaning in telephone communications as to first determine who the caller is before answering the call. Screen.
This may be a technical term. There are no DICT representatives here, but this could be a technical term that refers to creating screenshots, Mr. President. Remember, when you use your cell phone, you can capture through screenshots, pictures, or even videos. No, pictures, still pictures for that matter.
And that is a prohibited act.
That's a prohibited
I will
act.
go into that later because it seems to presuppose or envision several scenarios also. The
Yes,
screening.
but what would be your purpose in taking screenshots of data, for example, of a wiretapped, of a conversation or any mode of communication that is subject to wiretapping?
In order to disclose that, in order to make use of the
That's a
message,
presumption.
the
but
information.
because- Yes, Mr. President.
I will go into that a little later. Next question, please. On page 2, line 13, the bill defines the protected communications as, quote, private communications, conversations, discussions, data, information, messages in whatever form, kind or nature, spoken or written words of any person or persons, end of quote. How does a good sponsor define the qualifier private in private communications for the purpose of this legislation?
This refers to the privacy because it is enshrined in the Constitution, Mr. President.
And sometimes the meaning of privacy is something that is really hard to determine. Now, I'm raising that question because in the landmark case of Katz versus United States, this is a 1967 case of the U.S. Supreme Court, it was held that the government's activities in electronically listening to and recording the petitioner's words violated the privacy upon which he justifiably relied while using the telephone booth and thus constituted a search and seizure within the meaning of the Fourth Amendment. And it went on, the Supreme Court, the US Supreme Court went on to provide the standards in determining the existence of privacy. The US Supreme Court stated that protection may be extended to those areas where a person has, one, a subjective expectation of privacy, and two, that expectation is also objectively reasonable. I was constrained to really ask about a more definitive meaning of the qualifier private in private communications, because I remember that last year, former MMDA chief Francis Tolentino reportedly, based on news reports, threatened to sue individuals who records the conversations with MMDA officers for violation of the anti-wiretapping law. I have here some excerpts from certain news reports, because there was this private car owner in a video posted last September 23, apparently recorded her conversation with an MMDA enforcer who apprehended her for alleged speeding in somewhere in Commonwealth Avenue. And dun sa recording daw pong yun, the traffic enforcer was repeatedly telling that car owner, a lady car owner, that he would give her a traffic violation ticket. So during the conversation, apparently, I mean, it was actually very obvious that the traffic enforcer wanted
To
something,
extort.
wanted to extort. So I'm not sure whether former MMDA Chief Tolentino was correctly quoted, but he called the act as entrapment. And in an interview over radio, ang sabi daw po niya, I quote, "Sa ganung entrapment ay may violation din po ang nag-entrap. Mayroon tayong anti-wiretapping act." So this could be a gray area.
Chairman Tolentino may have a point there, Mr. President. While the MMDA traffic enforcer could be liable for extortion or attempted driver extortion, the lady traffic violator may also have committed violation of the Anti-Wiretapping Act, Mr. President.
That is one view. There could be another view. Well, in a U.S. court has previously ruled that police officers had no reasonable expectation of privacy in a conversation that occurred in a car on the shoulder of a busy highway.
I'm glad you mentioned...
Because they occupy positions where they would have a diminished expectation of privacy. So there is a school of thought which says that in situations like that, this is not entitled, the conversation that was secretly recorded by one of the parties, and here is the car owner, cannot be said to be entitled to the protection of the law.
You may also be correct, Mr. President, because it must pass the reasonable expectation of privacy test. And there are,
Yes.
in Ople versus Torres, it is a two-part test, Mr. President. One, whether by his conduct the individual has exhibited an expectation of privacy. And two, this expectation is one that society recognizes as reasonable. This is a decided case, and
Yes, Mr.
we are not
President.
very familiar with the circumstances of the apprehension and the recording of the traffic violator. But you may also be correct in saying that there's a reasonable expectation of privacy.
And that expectation
it's
is
up to the
also
court to-
objection.
It's up to the court to decide on the matter, Mr. President.
I should say that being a police officer, an officer,
A traffic enforcer.
a traffic enforcer,
He should
and
expect.
he should expect.
Then if he commits some shenanigans, then it is a prerogative of the one being extorted to put up a defense. or record something that may be of use if and when a case reaches the court.
And under such circumstance, I take the position that he may not be entitled to the protection of the law.
Well, as I said,
again-
you may have a point, Mr. President.
Thank you. On page 1, line 17, under the proposed section 1, the good sponsor proposes to expand the definition of forms of communications to include written words. Does the expanded law intend to protect written communications, including letters, chats, or SMS transcripts?
Even emails, Mr. President.
Because indeed, the intent of the original law was to protect spoken communications.
But
Even then.
in this day and age of technology, Mr. President, we send email messages to which
Yes.
should be protected.
So with this expanded definition, it would cover written and other forms of communication, perhaps even signed language.
Probably, Mr. President. At the proper time, you can consolidate all the other means of communication, and we can discuss about it, Mr. President.
Now, under the
The
second...
point is, I'm open to all the safeguards. And in fact, I'm very thankful that you are contributing additional safeguards. No? And during the period of amendments, I'll be very open. Because who knows, time would come that we, or I will be at the receiving end again, Mr. President. So thank you for all your contribution.
The foremost concern of this representation is precisely to safeguard
Yes.
against unlawful intrusion into the privacy. If we are to, because again, the weighing, the sensitive balancing of two interests, and sometimes it's not easy because it depends on the perspective. Of course, if you're a law enforcer, you would tend towards the interest for the state to enhance the law enforcement capacities. But if you are a private individual, and even a public official, you would tend to go in favor of really protecting the right of privacy. And I can never, ever support any measure, whether it's anti-wiretapping law or any other legislative measure that would trample our basic fundamental liberties.
That is well taken, Mr. President.
Now, on page 2, line 11 to 16, the second paragraph of the same section,
11 to 16.
yes, Mr. President,
Knowingly possess.
to knowingly possess. And it says he be a participant or not in the act or acts penalized in the next preceding section.
Yeah. I
Can
think that's
this-
self-explanatory, Mr. President.
Yes, Mr. President. Can this be interpreted to mean possession of letters not sent by or addressed to the possessor? Someone else is in possession of that private communication. He was neither the recipient nor the sender of that private communication or that letter. Will the possessor be liable if the letter is entrusted to him or her by only one and not all or both of the parties to the conversation, for example, a secretary or a clerk, to whom the recipient entrusted the safekeeping of a private communication in letter form, but without the consent of the sender?
For consistency, Mr. President, consent should be by all parties, not just one party in the conversation or communication.
Yes, so a mere possessor
Yes.
of a private communication.
If you are not a party,
If you are not a
then
party,
it violates privacy.
you
Because
have no
privacy,
business to disclose that.
yes, Mr. President, privacy presupposes privacy between two persons communicating.
How about chat transcripts? Would one party to the conversation who saves the
Transcript.
transcript without the knowledge or consent of the other party, be liable for possessing
Yes, Mr. President.
recorded communications?
Yes, Mr.
So that is very
President.
clear.
Yeah, that's very clear, Mr.
I
President.
think not too many people, or not many people are aware of that there could be in violation. Mere possession,
Mere possession should be a violation.
because there's no consent.
There's no consent by all parties involved in the communication or conversation.
Again, I'm constrained to ask that because we should note that there are modern forms of communication that electronically store records of conversation automatically or by default. And without any overt action from the recipient of the communication, he or she will have an automatically recorded copy of the communication.
Then by all means, he should destroy at first instance communication or conversations that he should not be privy to, Mr. President.
That's why I'm seeking for this clarification, considering that even a party to the conversation can be held liable. Would a party to an SMS or email exchange who does not delete the messages he or she receives be liable for possessing a recording of the private conversation in the form of undeleted text messages?
If he is caught in possession of that private communication, then he should suffer the consequences, Mr. President.
Even if he is a party and even not a non-party or not a party?
More so if he is not a party to the private conversation and he has in his possession transcript or records of that particular conversation. He has no business possessing that piece of even a portion of that conversation, Mr. President.
Again, this is very important because many people may not be aware of that. What about the overt act of taking screenshots of emails, chats, or SMS exchanges?
Lalo na po yun, Mr. President.
Supposing that the person performing the overt act is a party to the conversation, would this be considered as a secret and unauthorized recording of communications if you take screenshots?
Without the consent of the other party? Yes, Mr. President.
And would the possession of such screenshots be considered as a possession of illegally recorded communications, and therefore the other party to the communication can actually sue you?
Yes, Mr. President. Remember, Mr. President, during the hearing that we conducted, there was a suggestion to allow one party consent. And right away, we shut it down. There should be a consent by all parties, not just by one party. You can just imagine, Mr. President, if a law enforcement officer talks to a possible suspect and he secretly records the conversation even without a court order, and that's one party consent. That's the reason why, and I don't think it will pass the provision on privacy in our Constitution. In the U.S., it's allowed, Mr. President, in the United States, but in the Philippines, I don't think it will pass the constitutional provision.
I'm actually thinking more of conversation between two private citizens. And one opted not
To
to
record.
delete, and then worse, record those conversations
And disseminates.
for whatever purpose, and disseminates. That
That's a
is
clear-
covered.
That's a clear violation, Mr. President.
Given the expanded definition, let's talk about CCTV footages.
Okay.
That is covered.
Iba naman po yun. Yun yung reasonable expectation of privacy. Kasi CCTV cameras are everywhere. And
Yes.
when you go, say, inside a grocery, you should expect that you should be monitored. Hindi po wiretapping yon. But kung yung naglagay ng CCTV camera, in-extend pa doon sa kabilang bakuran, that's already intrusion. And there is no reasonable expectation of privacy.
That is very clear to us, Mr. President. But what about CCTV footages from hidden cameras that inadvertently record forms of communication, such as signed language, lip reading, private letters that are inadvertently recorded on video, are these considered illegal recordings
In
of
a public-
communications?
in a public
May
place,
I
Miss-
cite an example? A hidden nanny cam. Hidden nanny cam. There are households that have CCTVs intended to monitor how well a nanny performs her
Yung
caretaking duties. But somehow the CCTV inadvertently catches some form of conversation while also recording some form of criminal wrongdoings. For example, the act of maltreating the child or stealing. Would this be considered an illegal recording when it was only, it was, somehow it was in an inadvertent, it's a form of an inadvertent recording of something. It catches some form of conversations.
in your own residence, Mr. President,
Yes,
and inadvertently, the camera was able to catch some private, ano yun? Private acts, yeah. Thank you, Senator Gordon.
that's a
Kasi
good
baka
example.
mapasama yung sasabihin ko kaya. I think there's a decided case.
Would that be admissible?
Well, may I refer you to Victoria Hing versus Chua Chui. No? I think there's a decided case on this, Mr. President. No? Year number 179736. Very recent po ito, June 26, 2013. Isasabi rito, in this day and age, video surveillance cameras are installed practically everywhere for the protection and safety of everyone. The installation of these cameras, however, should not cover places where there is reasonable expectation of privacy, unless the consent of the individual whose right to privacy would be affected was obtained. Nor should these cameras be used to pry into the privacy of another's residence or business office, as it would be no different from eavesdropping.
So the answer
Now,
is
but-
inadmissible.
The situation that you have posited earlier, mukhang iba rito kasi kung bahay mo sarili, ma'am, tapos inadvertently nakatch mo yung private acts being performed by two persons, and you decided to keep it and even disseminate it, then there should be a gray area, Mr. President.
Yes, that is a
Even
gray
if
area.
it is your private residence.
We are asking these questions in order to avoid the law
That should be
being declared unconstitutional for being overbroad.
Yung
We-
alimbawa yung katulong, saka yung gardener o yung driver, tapos nahuli ng camera, and the amo decided to or decides to keep the proceeds, and without the consent of the two parties, no,
Yes.
yung say the maid and the gardener, then he may be in violation of the Wiretapping Act.
So can we say that the standard reasonable expectation of privacy is an essential element prior to prosecution of the case?
Yes, Mr. President.
And again, I have to ask about the exact meaning of certain terms being used in the proposed measure so as to avoid or preclude questions of constitutionality. for
I will always yield to
overbroad-
your
overbroad.
wisdom, Mr. President.
Thank you. On the same.
We are on the same page here, Mr. President. I'd like to emphasize that. So that's the reason why I said I will yield to your wisdom, because you have more experience. You are a lawyer of good standing and a bar top-notcher. So who am I to argue with you when things like this are subject of
But the good
discussion?
sponsor is equally learned and more experienced in the area
Sa dami ng kaso ko yan, Mr.
of law
President.
enforcement. Next question. On the same proposed section 1A, An exception to the regulated sale of recording devices is granted to the PNP.
Pinal sa akin.
There is a prohibition against the sale.
What's the page again, Mr. President?
This is proposed section 1A, still part of section 1A
Okay.
about the sale or importation.
27, line 27.
Yes, line 27. And the whole, actually it's the full provision of section 1A. The sale or importation by manufacturers, distributors, or any person or any mode, form, kind, or type of electronic, mechanical, or other equipment or device or technology now known or may hereafter be known to science, knowing or having reason to know that the design of such electronic, mechanical, or other equipment is primarily intended and used for the purpose, etc., provided, so I'm referring to the
Proviso.
proviso, provided that such requirement shall not be applicable to procurement under this act by the Philippine National Police, Philippine Drug Enforcement Agency, National Bureau of Investigation, the Armed Forces of the Philippines. Provided further that the said agencies may procure the equipment above mentioned either through limited source bidding or direct contracting, etc. My question, Mr. President, is that how can we prevent the PNP and certain scalawags within the PNP from reselling the equipment purchased through them to the local market?
They will be liable for technical malversation, Mr. President.
Because
they,
the PNP may purchase without authorization from the ICT.
They cannot. They can procure, but they should be guided by the provisions of Republic Act 9184, the government procurement law, Mr. President.
But no need for authorization from the DICT.
Because these are presumed to be government properties, Mr. President.
Yes. And may we know the basis for giving authority to these agencies to procure this equipment either through limited source bidding or direct contracting? Why are they being exempted from the general rule of open and public bidding?
Because by nature of their jobs, Mr. President,
Nature of their job or the nature of the subject of the procurement, the equipment? Limited source bidding or direct contracting? Because these are, isn't it that RA 9184 applies to all except the all, and the general rule under 9184 is open and public bidding for all procurement of public goods and services. But of course, in certain cases, limited source bidding or direct contracting. This representation just want to understand the rationale for applying the exception rather than the general rule under 9184.
the members of law enforcement units or law enforcement agencies, Mr. President, including the Armed Forces of the Philippines, are exempted from getting the permission of the DICT, unlike the private sector, because by the very nature of their job, law enforcement and conducting gathering intelligence information through wiretapping or listening to conversations of possible suspects. Kasi pag nalaban ng kabila, say drug lords, nalaman nila na merong equipment na ganong klase, ang PNP or NBI, alam naman ninyo na in this day and age of technology, very fast yung pag-counter. So the criminal elements may resort to procuring equipment to scramble or not make effective the equipment in possession of the law enforcement units.
Is that rationale the same for the exception under Republic Act 9184? I'm again referring to
9184,
the procurement.
procurement,
Why are they
They're
being
covered.
allowed to procure through limited source bidding or direct contracting when they are supposed to be covered by the general rule of open and public bidding? Is that the same rationale? Because not too many people must know about the purchase of those special equipments. And
Under
then-
9184, Mr. President, limited source bidding may be resorted to only in any of the following conditions: procurement of highly specialized types of goods and consulting services. So these are highly specialized equipment, so it should fall under
So it falls within the purview
Of
of
the
this
limited
type
source.
of procurement.
Yes, Mr. President.
Limited source bidding or direct contracting. But of course, the agencies concerned may opt still for open and public bidding. So this is just an authority for them, or is this a must?
Yes, Mr. President, but that's not too practical on their part to resort to open public bidding.
But the way it is worded in the proposed measure said agencies may procure the equipment above mentioned either through limited source bidding or direct contracting as provided under Republic Act number 9184. So it gives the impression that it is an option
It
on
is
the
an
part of the purchasing agency, either to go by the general rule of open and public bidding or under the exceptions, meaning the limited source bidding or direct contracting. So if the intent of the author, the good sponsor, is to really make it or bring it within the application of the exception, then would the good sponsor consider that it should at least be stated clearly in the body of this measure?
Thank you, Mr. President. I guess we should change the word may to shall.
But it doesn't mean, Mr. President, I'm actually amenable,
But thank you for the suggestion anyway, Mr. President.
because I have yet to be convinced that indeed everything, each and every purchase of this equipment, the special equipment, should not go
Through
via open and public.
That is, I agree, Mr.
bidding.
President.
Thank you, Mr. President. Let's proceed to the exempted crimes. Yes, we see that there is an expanded list of the crimes. So if I'm not mistaken, there are, 5 or 6 sets of offenses that were added to the exceptions. Is that correct, Mr. President?
I have not checked the exact number, but that may be correct, Mr. President.
And the good sponsor has insinuated or intimated earlier that he will be sponsoring a committee amendment so as to also include violations of the anti-plunder law.
I gave instructions to my staff already, Mr. President. I think it was an oversight on our part, not to include violations of 6713 and 3019.
And this representation fully supports that initiative. But I have to put on record certain comments in relation to that. I do believe that plunder and other grave forms
7060. Yes,
corruption.
Mr. President.
This
7080.
is anti-plunder law. Does the good sponsor contemplate only violations of the anti-plunder law or violations of the Anti-Graft and Corrupt Practices Act as a whole?
Everything, Mr. President.
So not just
Anti-plunder-
anti-plunder law.
Not just anti-plunder law, including all anti-graft and corrupt practices.
I-
Graft and corrupt practices, I mean.
Well, I certainly share the view that plunder and other acts of corruption is easily at least as, if not more, heinous
Heinous, yeah.
as the crimes already included in the expanded list, and in practice are actually less susceptible to usual methods of investigation due to the fact that it commonly involves participation of government officials who have the capacity to ensure their impunity. But this is a sensitive situation as it involves public officials, and there is a high risk that electronic surveillance could be misused for political purposes or for purposes of persecution. And
Then-
therefore,
They will be squandering their opportunity to gather evidence that are admissible
correct.
if they resort to illegal means of, or if they don't get any court order and just wiretap conversations, then they will lose the opportunity to use whatever output that they will get as evidence.
And would the good sponsor consider putting in more safeguards insofar as this particular?
As I said, I'm open to all the safeguards that you can think of, Mr. President, additional safeguards.
Would the good sponsor consider also allowing either Sandigan Bayan or the Supreme Court to authorize the use of such investigative methods and only under certain circumstances? And in other words, because the proposal is RTC.
RTC.
Because the old law did not specify which court.
So you're suggesting that for cases involving Graft and Corrupt Practices Act, it should be the Sandigan Bayan instead of the a regular RTC. I'm open to that amendment, Mr. President.
But this is Anti-Graft and Corrupt Practices Act, and we're trying to strike a balance here again between the need to really facilitate the gathering of evidence, especially for purposes of conviction, and also to guard against
Yeah.
cases of abuses or misuse or political persecution. Just a thought. I'm not really yet determined to introduce that particular safeguard.
But I think that's reasonable, Mr. President. In cases involving graft and corruption, the Sandigan Bayan should be the court that should be the issuing authority.
Thank you.
Yes, Mr. President. Because they can more or less appreciate more the application to wiretap conversations.
Would a good sponsor also consider including as among the exempted offenses violations of the competition law? But why am I
Competition.
broaching this idea? Anti-competition, particularly cartel cases, I think may be considered in the list for crimes in which courts may sanction interception and recording. This is necessary to give teeth to the newly enacted Competition Act, specifically and uniquely conducted in order to avoid, because certain anti-competitive acts are specifically and uniquely conducted in order to avoid detection. Medyo complicated po ang mga cartel cases, mga anti-competition cases ho natin. Fear of detection in the US has made them more difficult to investigate, and wiretapping has been critical in successfully detecting, investigating, and prosecuting them. A failure on the part of other countries to be as vigilant could create safe havens, as international cartels are keen on avoiding US authorities because they are covered, they are among the exempted.
Mr. President, my
offenses.
attitude is we might as well include as many cases that we can think of. No?
As a matter of fact,
So we won't be amending, we won't keep on amending this bill if it's passed into law.
as a matter of fact, Mr. President, the fact that this proposed measure proposes to include already violations of Anti-Money Laundering
Yes.
Act, it seems that it really would be covering a lot more offenses, because we all know that the list of
predicate crimes.
predicate crimes under the AMLA have been continuously expanded, and therefore could cover other offenses that are not initially part of the list of the exempted offenses under this measure.
That is the implication, Mr. President.
So perhaps we can look into, or we can review the list of the predicate offenses under Anti-Money Laundering Act. And there's no need for us to add more, because plunder and violations of anti-graft and corrupt practices are already also a predicate offense under AMLA to avoid a longer list, or to avoid duplication of the list of accepted offenses. Next point. Can we proceed, please, to the
Yes, Mr. President.
judicial authorization? I appreciate the fact that, compared, of course, to the old law, this proposed measure has indicated detailed procedures. And is it an accurate understanding of the proposal that even if a particular officer has been authorized to secretly listen to and record certain conversations because they fall under the accepted offenses, the product of that authorized act of wiretapping cannot readily be used without
Court
express
authorization.
court authorization?
That is correct, Mr. President.
And I think that is a very good safeguard. So there is no automatic use of the product of the authorized act of interception without court authorization.
Not only that, Mr. President, without written authority from the authorizing court, the applicant or the person cannot remove, conceal, destroy, discard, or reveal any of the above-mentioned tape, disc, other storage device, meaning probably USB, excerpts, and any copy thereof. And within 48 hours, he should deposit all the proceeds to the authorizing court, Mr. President.
And as a matter of fact, there is also the requirement of notice to the affected party. Would a,
Yes.
would a good sponsor clarify to us exactly when is the notice to the affected party or to the party whose conversation, whose message, whose info is subject of the authorized interception?
Within 90 days, before or after the wiretapping, or after the applicant self-submitted to the court in a sealed envelope the proceeds of the wiretapped conversation or whatever, within 90 days ba yun?
The court
Within 90
order,
days, yeah.
the court order has a life of
Of 60 days.
subject to extension of 30 days.
Non-extendable period, another 30
For
days.
good cause, for good cause. So it can be a total of 90 days.
Yes.
Now, within that period of 60 days or 90 days, as the case may be, would they be able to notify? They cannot notify
They cannot.
the affected
For
party,
obvious
otherwise,
reason, yes,
yes.
Mr. President.
So the notification to the affected party is after the expiration of the order.
Within 90 days from the expiration of the order, the individual or individuals whose communications have been intercepted and or recorded shall be notified.
What is the rationale for the period of within 90 days from the expiration of the order, when the expiry date of the order itself is 60 days or 90 days? So after the lapse of either 60 days or 90 days, then we have to wait for another period of 90 days within which that notification can be given. Any special reason for that?
I think the reason would be that the party whose communication or whose conversation was wiretapped, yung recipient ng order, would be able to prepare his or her defense. On the part of law enforcement, para sa case build-up naman siguro, kaya within 90 days ang period.
We are referring here to the act of notification.
The act of notification. On the part of the law enforcement agent that sought authorization from the court para mai-prepare niya yung case build-up prior to the filing of cases. On the part of the recipient, of the court order, it's probably to give them time, him or her time, to put up his or her defense.
Thank you. Now, in giving the authority to intercept, to record, to listen, as an exception to the rule, there are, of course, standards. There must be a showing, number one, that there are reasonable grounds to believe that any
Yes.
of the crimes enumerated in Section 3 has been committed, or is being committed, or is about to be committed. Number two, that there are reasonable grounds to believe that the evidence that will be obtained is essential to the conviction of any person for, or to the solution of, or to the prevention of any of such crimes. And three, that there are no other effective means readily available for obtaining such evidence. I have no problem about that it is meant to obtain evidence that is essential to the conviction of any person or to the solution of a crime, but let's probably talk about the prevention of any of such crimes. And under the first standard, so either a crime has been committed, or is being committed, or is about to be committed. And when we use that phrase, about to be committed, there must be imminence of the commission of the crime.
We're
That's-
following the standards of a citizen's arrest, Mr.
The
President.
citizen's arrest. But sometimes it's also a gray area, about to be committed. How imminent is the commission of the crime? I have to ask this question because I can cite a fairly current issue about the so-called plot to oust the current president. And theoretically, assuming there is such a plan to oust, that certainly would fall under any of the exempted offenses.
About to be committed.
Sedition, or inciting to sedition, etc. So how do we interpret this? About to be committed. Is there imminence? Because, you know, certain personalities, especially of our party, Liberal Party, is being accused of that. So would that justify, theoretically, wiretapping because we are perceived to be part of a plot, allegedly, to
I
oust?
think we should leave it to the sound discretion of the judge, Mr. President, because there will be, although it's ex parte, there will be a hearing to be conducted by the judge on the applicant, and even the witnesses will be heard by the judge, who will issue the authority to wiretap.
But we
it's
are
not-
clear. But we are clear that this is supposed to be is the element of imminence, because if you cite as a parallel the standards for warrantless arrests, that is exactly what is contemplated. Warrantless arrest. There shouldn't be any substantial gap, time gap.
Mr. President, when you present your evidence, you should prove and you should be able to convince the judge that there's really imminent danger of an ouster. Say, for example, the example that you cited, is there really imminence to oust the sitting president? I think we should leave that to the sound discretion with the judge.
Thank you. Again, it should be clear, it is imminence, about to be committed. The third element, Mr. We can allow interjection. It's okay with me, Mr. President?
I'm being surrounded by Liberal Party members, Mr. President.
No.
Yes,
Mr.
sir.
President, with the permission of,
recognized.
with the permission of the two colleagues on the floor, using the Liberal Party is a bad example because it interjects.
I did not give that example,
Yes,
Mr.
I
President.
know, you did not. It's
your party mate.
Yes, it's a bad example. But anyway, I have underscored also as a concern that a warrant or the application can be based on the allegation that a crime is about to be committed. Because here, you're asking for authority because you believe that a crime is about to be committed. Be careful, because in effect you're trying to read the mind of the person you're trying to tap, because you're saying about to be committed. It can be interpreted as a state of the mind, you know. So it is extremely dangerous that an authority to wiretap is granted because the applicant believes that the person to be tapped is about to commit a crime. In
I guess
practice-
there should be independent circumstances that would make the applicant think that that a crime is about to be committed.
Yes, that may be good in
It may not
theory.
be, arbitrary.
Yeah, that may be good in theory, sir, but when we go on a day-to-day application of this power, to me this is very dangerous, because
Actually, to be very honest about it, we just copied and pasted the old law.
about to be committed?
Yes, that there are reasonable grounds. This is RA 4200, Mr.
Okay.
President. One, that there are reasonable grounds to believe that any of the crimes enumerated here in above has been committed, or is being committed, or is about to be committed.
Yeah, okay. Regardless of that being found in the old law, we must re-examine now the policy behind that, given that today we are confronted with all kinds of situations which may not have been prevalent at the time. It's a very, to me, anyway.
I appreciate your apprehension kasi hindi naman laging nasa ibabaw tayo, Mr. President. Darating ang araw, baka tayo naman yung hinahabol.
Correct.
So I fully appreciate your apprehension, Mr. President.
I'm glad that, I couldn't resist but intervene at this point. I will probably touch that when my time for the interpretation. But just to inject at this point that at least I am deeply concerned about the power to grant the authority to wiretap, where in the conclusion of the applicant a crime is about to be committed. That is, to me, is very dangerous.
Pero ano yan eh.
It's very, as Senator Gordon said, it is very speculative. You're trying to read the mind of the person you are going to wiretap.
I think the judge will ask for independent circumstances or evidence to show that a crime is about to be committed.
Sir, yes.
It will not be a standalone requirement, Mr. President.
Yes, sir. Except, Mr. President, that we have judges who would issue search warrants for those who are already in the provincial jail. So that is the kind of judge that we have. So that is why we are concerned. In an ideal world, maybe we can be comfortable. But when you see an RTC judge issuing a search warrant of somebody who is in the provincial jail, then you have to start thinking whether this power is something that we can proceed,
Yes,
be
we
comfortable
have
with.
to be afraid.
Thank you, Mr. President.
Very afraid. Thank you. I think at the very least, adding to that discussion, I think at the very least there must be overt acts or proof of overt acts that tend to show the attempt to commit a crime. So, well, we can again discuss this in due time. And in the meantime, I can think of some possible
Mr. President,
amendments.
I'm always on the same page with the distinguished lady because, after all, nothing is permanent in this world. You may be in your situation now, I may be in your situation later. Who knows? Senator Recto may be, in a similar situation where you are in now.
And that's why
Anybody for that matter.
everyone should really be concerned.
And since we are the ones discussing this bill for enactment into law, then we might as well input all the safeguards that we can think of.
Thank you. About the mention of Liberal Party, it was with a heavy heart that I had to cite that example. I'm just going by certain reports, certain media reports. that some personalities are being accused of plotting the so-called austere of the president. So reading this, what if somebody applies for court order on the assumption that certain personalities are about to commit the crime of sedition or inciting to sedition in the form of plotting the alleged austere of the president? Just putting that on record. The third requirement, Mr. President, that there are no other effective means readily available for obtaining such evidence. I feel that this requirement,
It's too stiff.
this is a requirement that may not be strictly complied with. And I think it would be more followed in breach than in compliance. There are no other effective means readily available for obtaining such evidence. And the only one who can really determine whether there are other effective means readily available for obtaining such evidence are the law enforcers themselves. And all that they have to do is just to represent to the judge or
That
to
there
the
are no
court that there are
other-
no other means. So I'm not sure whether this would really serve any other purpose, although as a form of an additional safeguard, this is acceptable. But I'm just saying that I don't think it has any added value.
I'm looking at it in another way, Mr. President. This really will make it very hard for the applicant to secure a court order. Imagine there are no other, that there are no other effective means readily available. It will be very difficult to secure a court order to wiretap, Mr. President.
Thank you, Mr. President. Now, the proposed measure says that the written I'm referring to Section 3C, lines 13 to 19 of page 9. The written application, together with supporting documents submitted and written order granted by the authorizing court, shall be deemed and are hereby declared as classified
That is correct, Mr. President.
information. For the benefit of the public, would the good sponsor tell us what exactly is the classified information?
Classified information is information that cannot be divulged to the public, Mr. President,
Without, again, written order.
without a written order from the court.
There can be situations where this facts or this information may be disclosed to the public. And may I refer again to, may I also refer to page 10, line 16 to 22. This is about the disclosure of the identity of the authorized applicant. In no case shall the identity of the authorized applicant be disclosed except upon written order of the authorizing court after a determination that a public interest in the disclosure of the information outweighs the public interest in keeping the information secret or confidential. Again, this is not easy to really apply. May I ask the good sponsor to cite to us examples or instances wherein the public interest in the disclosure of the identity of the authorized applicant, which is deemed a classified information, outweighs secrecy, meaning that the intercepted and recorded communications, I'm asking for an example of a situation where the identity of the authorized applicant may be disclosed by authority of the court because the court has determined that the public interest in the disclosure outweighs the public interest
When
in
there's
keeping it
abuse,
secret
when there's abuse or violation, Mr. President,
by the applicant.
by the applicant, then the court may authorize the disclosure of the identity of the applicant.
And abuse here would mean,
Violation of the court order.
because what if the information gathered through the authorized act of interference and recording is so crucial and essential for the conviction of a particular crime. And shall we risk disclosing the identity of the applicant because
Well-
of certain abuses committed by the applicant?
If the applicant, for example, Mr. President, if the applicant sells the proceeds or is compromised, no, then he should be answerable to some criminal violations, no, criminal acts, and therefore, I think the judge should decide to disclose his identity, and as a matter of course, because he'll be facing charges, Mr. President, because it is a violation under another provision of this bill.
Thank you. Next. Section 3F, about the disposition of the deposited material. Again, this is a very good safeguard because the information, the data gathered through the authorized act of interference are supposed to be deposited with the court, and therefore cannot be used, cannot be shared, cannot be given to anyone also without the express authority of the court. And again, this shall be deemed to be classified information. The sealed envelope or sealed package and the contents thereof, which are deposited with the authorizing court, shall be deemed and are hereby declared classified information. And it shall not be opened, and its contents shall not be disclosed, revealed, read, replayed, or used as evidence unless authorized by written order of the authorizing court, which shall not be granted except upon motion, with due notice and opportunity to be heard to the individual subject of the above-mentioned court authorization. May I know what kind of proceedings are contemplated? Because this mandates notice and hearing. Is this meant to be summary, open, in executive session,
Summary, Mr. President. Summary proceedings.
summary yet open?
Yes, Mr. President.
Can be open. And that is for the authority to use the contents of that sealed envelope.
Yes, Mr. President.
And moving on, under the same provision, provided that within 90 days from the expiration of the order, the individuals whose communications have been intercepted and or recorded shall be notified of such fact. I think this was clarified earlier, 90 days from the expiration of the order.
Of the order.
So it could be on the 61st day, 62nd day,
Or
if
on
there
the
was no
91st.
extension,
Yes.
or the 91st.
91st day.
Or right after the extended period.
Yes, Mr. President.
Thank you. Inamis ba tayo?
Distraction.
That should be all. And thank you for the patience of the good sponsor in responding to the questions. Thank you, Mr. President.
Yeah. Thank you, Mr. President.
Majority Leader. Mr. President, 1 minute suspension, please. Session is suspended. Ready to resume, Mr. President. Session is resumed. Mr. President, I move to suspend the consideration of Senate Bill 1210.
Any objection? There being none, consideration of Senate Bill number 1210 is hereby suspended.
Mr. President, I move to adjourn the session until Monday, January 23 at 3 p.m.
Is there any objection? There being none, the session is hereby adjourned until 3 o'clock in the afternoon of Monday, January 23, 2017.